Good morning and afternoon, everyone. Thank you so much for joining us today. My name is Imani Rupert Gordon, and I'm the Executive Director here at the National Center for Lesbian Rights. Just a quick housekeeping thing. At the bottom of your screen, towards the right, you should see a caret, and that will, if you want to have closed captioning up, you can just go ahead and click that at the bottom of your screen. I know this has been an incredibly long week for all of us, so I hope that you're able to offer yourself some patience and some grace this week. Yesterday, we heard oral arguments for the highly anticipated case, Fulton versus the City of Philadelphia. And for you, those of you that don't know, this is this decision that will determine if groups that receive public funding will be able to receive religious exemptions that will allow discrimination of LGBTQ people. As a non-lawyer doing this work, I always like to provide some context for the discussions that we're having. So I want to let you know that you're sitting in front of three amazing senior members at NCLR. Their kindness is matched only by their brilliance. So if you don't understand something, to make sure to ask a question, and then we'll make sure to get an answer for you. You can put it in the chat or in the Q&A. Remember, this work is for all of us, not only the folks that are trained as lawyers. So ask all the questions that you like. For background, one of the plaintiffs in the Fulton case is Catholic Social Services. You might see that written or said as CSS. So the City of Philadelphia receives government funding to find home placements for children in the foster care system. In order to identify and vet potential foster parents, the city contracts with dozens of private agencies, which is a common practice, and CSS is one of those agencies. When it was discovered that CSS discriminates against same-sex couples by refusing to consider them as potential foster parents, that's when they stepped in, because this is a violation of the contract that the city had, and this would, this would be a violation of the contract that the city had, because they shouldn't be discriminating on the basis of sexual orientation. When they learned of this, the city didn't renew the contract with CSS because they weren't adhering to this non-discrimination requirement by refusing to see same-sex couples. Catholic Social Services' main argument is that the Constitution protects the free exercise of religion. So they believe that even though they refuse to comply with the terms of this contract, namely discriminating on the basis of sexual orientation, that shouldn't compromise their contract with the city, because they object to it based on their religious beliefs. This is particularly important right now because the funding that the City of Philadelphia is receiving is from the government. So this is broadly a case about religious exemptions, which we really should start looking at, because we're going to start seeing a lot of these in the future, especially given the recent Bostock decision from the summer, and that some of the justices have signaled that this is what we're going to be looking at next, and honestly outright said that this is what we'll be looking at next. So something else that you might want to pay attention to is how they talk about the foster care system in the oral arguments, and the child welfare system in general. I know several of you on this call are very aware of the intersection between racism, LGBTQ identity, and other underrepresented identities in relation to the child welfare system. But we really want to talk about the damage that's done when we don't have arguments that have a really strong social justice analysis. And then the last thing I want to mention is that this is one of Justice Amy Coney Barrett's very first cases on the court. And so her questioning really gives us some insight about her strategy and how she might look at discrimination of LGBTQ people and intersections of identity on this case, but also in the future. And I know that's something we're all thinking about. So with that said, I'm going to turn it over to our amazing panelists. Today, we're joined by Shannon Mentor, the legal director here at NCLR, Kathy Sakamura, the deputy director and family law director here at NCLR, and Shannon Wilbur, the youth policy director here. Thank you so much, everyone, and go ahead and take it away.
Sorry, I'm gonna get myself off mute there. Hey everybody, and thank you, Imani. So let me just say, I feel like multiple books could be written already about this case just based on the briefing and the oral argument. It is really there's so many dimensions to it, and as Imani pointed out, it's one of the first cases that we've seen with the new court, with a 6-person sort of super majority of extremely conservative justices, now including Amy Coney Barrett. And I will just say, start off with the kind of human interest side of this, that you could really feel the difference in the dynamic of the court. You know, you could just, it's so clear now that there's, you know, the majority of the justices are coming from a very conservative point of view. And Justice Ginsburg's voice was just, you know, palpable in its absence. And it was really hard to be really kind of no one left to stand up for a robust enforcement of civil rights and equal protection, except for Justices Kagan and Sotomayor. And they really tried. They tried very hard, and Justice Breyer to a significant degree as well. But it's a different court. Anyway, to get, you know, some of the issues are, depending on how the court rules, this could either end up being not a very significant case that doesn't really do much to change the existing law, or it could end up being really chaotic, and we could be living in a whole new constitutional landscape. I'm not really sure which way the court is going to go. I'll give you my guess in a minute, but who knows? You know, it's, as we've seen lately, even they're just very unpredictable. Sometimes in good ways, but mostly good ways. So, you know, there was a decision back from 1990. Justice Scalia wrote it, saying it was the Employment Division versus Smith. You know, practice constitutional law, super familiar with the case, which, you know, said that when the government is enforcing a law, as long as the law is neutral and is applied generally in an even-handed way to everyone, the fact that the law may happen to have a disparate impact, you know, a negative impact on people who hold certain religious beliefs is neither here nor there. Like that you can't invoke religious liberty as a way to say that you don't have to comply with a law that is neutral, applied to everyone, and was not enacted specifically to target certain religious beliefs. So that's kind of the baseline law right now. And the questions that the court agreed to consider when they took this case were whether the lower courts had applied that law, that precedent in Smith correctly, or whether the court agreed to decide whether they want to like reconsider Smith and adopt some new rule about how, you know, when you can invoke religious liberty as a reason to not comply with a law that's generally applied to everyone else. So if they did that, obviously it would be a really, really big deal if they decided to completely change that law. So when when you got down to the oral argument earlier this week, it was really interesting. The court focused on a few key issues. One thing that is like a major point of contention, and I would say even confusion, is what is Catholic Charities? So the people on sort of our side, the city of Philadelphia, and the people who think that the city's decision to not renew its contract with Catholic Charities was the right decision, are arguing that this is real, that Catholic Charities is really just indistinguishable here from the government itself, that this is like a government function. The government by law has to, it's the one responsible for these foster kids. It's the one who has a legal obligation to evaluate and certify potential foster parents and adoptive parents. The government could just hire workers to do that. They could hire social workers that are direct government employees to carry that function out. And that if that were the case, then you don't even get to Smith, really. That's just when the government is acting in its own, you know, using its own money and doing a purely public function, the government can make its own policy choices. And the government has no obligation whatsoever to accommodate a government workers, religious objections to doing a government job. That would be, you know, that, and that's the context in which the government's interests are in enforcing its own policies, which in this case, include non-discrimination. are at the very strongest and highest, and there's really not any countervailing interest on the other side. So the court seemed like it was the conservative justices were really not going along with that view of Catholic charities, and we're asking all kinds of questions, trying to say, well, no, isn't Catholic charities really like at least an independent contractor? But really, where they really seem to be trying to head is to say that we should think of this case more as like the government licensing independent entities to perform functions, in this case, certifying and evaluating foster parents and potential adoptive parents. Sorry, I hope this could sound, especially for people who are not lawyers or who don't even practice in this area of law, this may sound really like getting down into the weeds, but it's actually pretty important, because if the court goes along with the idea that what's going on here is more like licensing than direct government action or even a government contractor, then the standard that they're going to apply is really different. If this was a licensing situation, then then Catholic Charities does have a much stronger claim that they should be given a pass because complying with the city's requirements, contractual requirements, conflict with their beliefs. So there was a lot of back and forth about that. And I will just say that Amy Coney Barrett in particular was trying very hard, I think, to lay a foundation for the court to say that this is a licensing situation rather than direct government action. So we'll see how that goes. We'll just have to stay tuned and see what happens on that. There was, other than that, I'll just hit on a couple other things quickly, and then let's see what Kathy has to say about it. But there was a lot of discussion about harm, like a lot of the conservative justices in particular really hammered home the point that no same-sex couple has actually ever been turned away by Catholic Charities. Some of the other justices, Sotomayor and Justice Kagan, pointed out, well, that was, there's probably a good reason for that, because they know they're not going to get served by Catholic Charities, so that we really can't draw any conclusions from the fact that we can't point to an actual instance of somebody getting turned away, because if you already know you're not going to get served by Catholic Charities, you're not going to go there. That there's no like record of discrimination, of actual discrimination, or of their policy actually being enforced against couples coming to them for services is liable to play a pretty significant role in whatever decision we end up getting. Then another big source of a lot of confusion and a lot of back and forth in the case is whether or not the city allows other so-called exemptions from the anti-discrimination policy. So there was so much confusion about the difference between what Catholic Charities does, which is just say, hey, if you're a same-sex couple, we are not even going to evaluate you in the first place. We're just excluding you from our services. Go somewhere else. Between that, and then between what happens when you get to the stage of matching an individual child with a particular foster family or adoptive family. When you get to that stage of matching a child, then the agency will look at everything about that foster family, including potentially protected characteristics like family status, and possibly even race in some cases. So the conservative justices seem very, very wedded to the position that individualized consideration of all relevant factors at the placement stage amounts to exemptions from the anti-discrimination law, which would then mean that the law is not neutral and it's not being even-handedly applied, that they're trying to say that the city allows all kinds of other exemptions in other situations and contexts, and that it's only when it comes to Catholic Charities and its religious beliefs about same-sex couples that they're not allowing an exemption. So if they go down that path, they would be saying that even under Smith, the existing precedent, Catholic Charities perhaps should win because they're not being treated the same as everyone else when it comes to the city's willingness to grant exemptions. I'll stop there, except to say one last thing, which is that several of the justices, including even Amy Coney Barrett, spent a lot of time questioning both sides about what would happen if Catholic Charities didn't want to place kids in homes with interracial marriages. So it's one possible issue in this case that may come out in the decision is whether or not the court would say that race discrimination gets treated differently than every other type of discrimination. So that could have a lot of ramifications if the court decides to go down that path. So anyhow, last thing I'll say about all this is that I think after listening to everything, the argument that it's most likely that the court will not do something broad and sweeping, I hope that's true. I think they will do something as narrow and incremental as possible, which still may not be great, but it would certainly be better than them, coming up with some whole new framework for analyzing these cases that recognize some really big, new, sweeping religious exemptions. But who knows? They might do something. They might end up doing something quite broad. As you can tell, I do think they're going to rule in favor of Catholic Charities in the case. It just seems like too many conservative justices on the court now, and they seem to really be taking one over by the arguments that Catholic Charities should be granted some kind of exemption here, or that what happened here was in some way improper. So I think the question in my mind is just how narrowly or broadly will that decision, will it end up looking? Okay, I'm going to stop there and Kathy, kick it over to you.
Thanks so much. I'm Kathy Sakimura. I'm Deputy Director and Family Law Director here at NCLR. My pronouns are she and her. I think I just want to talk a little bit about more generally about the government's compelling interest in addressing discrimination. Because obviously this case, although it is focused on the certification of foster parents, has implications far beyond that. It has implications beyond the child welfare system, of course. Really, this is about whether or not there can be religious exemptions for private entities who are essentially acting as government actors, or just more broadly, can religious entities just be excused from following anti-discrimination laws? But I think also it's really important to look at this case as being about the child welfare system itself, that this case is really focused on the certification of foster parents. And so a lot of the discussion is about how there's all of these children, and this was discussed in the oral argument as well, that there's, all these children in foster care who don't have foster homes, who are in group homes, and we need Catholic social services and other entities like them to certify foster parents and place these children. But really what is missing from this discussion is, why are so many children in the foster care system? And are they really properly there? Because the discrimination doesn't just happen at the level of certifying foster parents. The discrimination is also happening at the point where children are entering the foster care system. So we know from lots of research that there are vastly disproportionate groups of children who are entering the foster care system and remaining there for longer based on race, sexual orientation, and disability. And that is and the vastly disproportionate numbers, as well as the bases for their removal, really shows that many of these children do not belong in the child welfare system at all, and that they are harmed by being part of this system. And the government has an obligation to ensure that the discrimination is not happening at any level, including, and almost most importantly, the initial removal of children from their families when they can safely remain there. And so I think that's a conversation related to this case that hasn't had a lot of traction, because there is such a focus on the other broader impacts of this case, which are also terrible and really need to be addressed. But just to give you a little bit of an idea, the groups of children who are most disproportionately represented in the child welfare system are Black and Native children, children who have disabilities or whose parents have disabilities, and LGBTQ youth, and children with LGBTQ parents. And in fact, one study that looked at Black mothers found that Black, lesbian, and bisexual mothers were much more likely, even compared to heterosexual Black mothers, to have their children removed and have their children remain in the child welfare system for longer. So that, of course, as we would expect, intersecting identities in these groups of children who are disproportionately affected are even more affected by this discrimination. So that, I think, is just such an important piece of this case, that really, what is the child welfare system and what is the need to place children in foster homes, and how can the government best address this discrimination? It goes so far beyond this specific instance, of certifying foster parents by CSS, and really looking at the child welfare system as a whole, which sounds like obviously it's about child welfare, but really is about family regulation and about the policing, essentially, of families through the threat of removal of their children based on cultural and racial norms that enforce white supremacy. And I'm really excited that Shannon Wilbur, our youth policy director, is here to talk more about the child welfare system as a whole and about the movement to transform it.
Morning, afternoon, everybody. I'm Shannon Wilbur, Youth Policy Director, she, her pronouns. Really happy to be here today, and I thank you, Kathy and Shannon, for that great contextual information. I just want to add one little detail about the Fulton case before I talk about our child welfare work generally, which is that I just want to remind folks that NCLR filed an amicus brief in the case. And it really focused on the issues that Kathy has really well described, which is kind of focusing the messaging and the importance of how the system itself is so racist, frankly, and decisions are made at every stage of the process, including at the very front end, that influence the way the entire system works. And so we wrote an amicus brief that really focused on this being simply allowing Catholic social services to discriminate was really just another layer of discrimination in a system that already operates in a very discriminatory fashion. And that all types of discrimination end up being very harmful to the children and families that the system is designed to serve. So I wanted to just talk generally about our child welfare work, which for many, many years focused on the overrepresentation of LGBTQ youth and families, and particularly those of color, and really looked at it was a reform package, really, looking at what do we need to do to tweak the system to ensure that people are treated fairly, that to improve outcomes. I would have to say that in more recent years, because of many of the things that Kathy just described, we've really shifted to the front end of the system, meaning recognizing that far too many children really would be better served in their families and communities with appropriate supports. And in particular, of course, that impacts poor and low-income children and families, families of color, primarily Black and Native families, and again, LGBTQ families. So we've really been shifting to what I would call a primary prevention kind of model, where we're looking at working with jurisdictions to really think about what needs to exist in communities, to what kind of social safety net and set of services to truly address the needs of families, to prevent the need for family separation, particularly in these very vulnerable groups of folks that we see overrepresented in the system to begin with. So focusing on necessities, literally food, shelter, childcare, jobs, the kinds of things that permit families to care for their own children. Where children, by the way, do much, much better in their own families and communities. The outcomes for kids in foster care are really horrible, and they have been for a very long time. And there have been some really exciting developments recently, and we were working very closely with the Center for the Study of Social Policy, and University of Houston, which have begun something called the Upend movement, which is really looking at completely dismantling the current child welfare system and replacing it, very important, replacing it with something that does what I was just talking about a moment ago, which is looking at the structure and practices that operate in a very racist and unfair manner and sweep way too many families into the system, dismantling those and replacing them with the kinds of supports that permit and help families care for their own children in their own communities. So it's a really exciting movement. It's just launched very recently. In fact, they just had their inaugural convening, I think, a couple of weeks ago. I really recommend that all of you take a look at the convening is on YouTube. It's upendmovement.org. There will be opportunities, I think, moving forward for NCLR and others to collaborate with Upend. And right now, I think a lot of it is just really focusing on education and talking to folks just like we are right now about how does this system currently operate and what would we like to see in its place. So I am going to stop there and see if either Kathy or Shannon have additional comments or whether we want to take questions.
I just wanted to give a shout out to Nancy Polikoff, who is on this webinar as an attendee, for her scholarship in this area and really raising the attention, trying to, raise the attention on this issue, which is, so deeply impactful to so many families and is such an LGBTQ issue, because LGBTQ parents, and especially LGBTQ parents of color, are deeply impacted by the child welfare system.
Yeah, same. The issues that Nancy is raising and that Shannon Wilber is talking about and that the Upend movement is trying to address, they're really so important. And it's hard to figure out how to navigate this moment when this Fulton case is in front of the Supreme Court and the focus is entirely on discrimination against same-sex couples, which is no mention or acknowledgement of the really pervasive discrimination that's leading to these kids, most of the kids, needing placements in the first place. So we're trying to raise these issues in a way that people can understand, and just they're important. We should be talking about them. I'll just say what Kathy said. There are a lot of parents in our community who have lost their kids with the state coming in and taking the kids away for no good reason whatsoever. It's just based purely on homophobia, transphobia, and lots of times other issues too. If it's LGBTQ parents of color, racism, there's a lot of huge bias against just poor people. It's really brutal, and we've got a firsthand view of that. We haven't done as much work on that as we want to. We really are trying to shift resources and energy to help that part of our community, people who are facing that in our community. But we had a case in the last year, I think, that was a mom. What's the state again? In Michigan, right? Who had 3 kids. she was very poor, really struggling economically, financially. And one of her kids, the youngest, was gender nonconforming, really gender nonconforming. And she, despite having very limited resources, had sought out professional help to find out how can I best support my child. And what she heard from all the therapists is like, you should just like support your child's identity and see what happens. And so she was being, very supportive to the child around the child's gender nonconformity. Well, some state official, a social worker, found out about this, and she just got investigated by the state like relentlessly, and they took her kids away, all three kids, for absolutely nothing, no other reason than that they thought she should not be being supportive of her child being gender nonconforming. So, we got involved. We also had a big firm working with us. So even with NCLR and an enormous big law firm, we were there every step of the way. They had a whole trial on this. We lost. Even with like the very best representation, because the bias in the system was staggering to see this unfold. Then we appealed to the Michigan Court of Appeals. We lost again. Michigan Court of Appeals said, well, there's really hardly any evidence here of that this parent has done anything wrong, but we're just going to defer, to the discretion of the line staff that work for the state social services department. So then we were in the process of appealing to the Michigan Supreme Court. I will say the Michigan Supreme Court, as soon as we filed our appeal, they immediately issued an order saying that the two other kids had to be returned to her. So that was an encouraging sign, and we were optimistic that the Michigan Supreme Court would correct this gross injustice. But in the meantime, Dana Nessel was elected to be the Attorney General of Michigan, and we brought this case to her attention, and she responded immediately in a very appropriate way to tell the state agency, we're dropping this. We are not going to pursue this case against this mom. And so we didn't have to end up going to the Michigan Supreme Court, and she got the child back. But I just share that with you all because it was a very educational experience for all of us. It's one thing to know intellectually how biased this system is. It's something else to see it up front and personal. It was really, really, really eye-opening. I don't know, Shannon or Kathy, y'all have anything more to add on that?
Boy, it's hard to even remember that case because it was just so horrible and frustrating what happened. Some of the other things that happened in that case are really typical. And one of them was that once this family got into the jaws of the child welfare system, and that's literally what it's like, standards completely change about, what constitutes abuse, what the agency can require of the parents, the ways in which they're overseen and surveilled, and literally police at the door. Her house wasn't clean enough. Everything she did was held against her and was raised, openly by the counsel for the agency, and was used against her in the ultimate decision to have her children removed from her. So that, she just, there was no way she could meet their standards. There was absolutely no way. She was very poor. She had very few resources. During the pendency of this case, she was homeless more than once. She's on the child abuse registry in the state. The child abuse registry, which meant that she could no longer engage in her profession, which was childcare. She was a childcare worker. So now that she's on this registry, of course, she can't get a job. So, it just worked against her in so many insidious ways. And it's not an unusual case. That's what happens. And that's why I say that we're really, really engaging with thoughtful partners who are wanting to just dismantle these structures and the way that they operate. Everything from what is the definition of abuse at the front door? Because if you look at the population of children in child welfare, the vast majority of them are there because of neglect, which is a proxy for poverty, really. So how are we defining abuse, and what are we doing with families who are struggling, besides just separating them from their children? And the financial incentives that the federal government, when do states get child welfare funds? For what activities? Imagine if what happened is they were flipped, and instead of getting federal money when you separate families, you get federal money when you keep families together. That would be radical, and that would be more in keeping with the actual objectives of the system, which are to promote the health and well-being of children who demonstrably do better in their own families and communities. And finally, the whole mandated reporting system, where there's all these people who are obligated to report what they think might be abuse to Child Protective Services, and those reports are completely confidential. So when you think about how that operates, there's just, again, that's sort of a piece of the surveillance that we see happening with primarily low-income families of color. I could get on this soapbox forever and ever, but I'll stop there.
I just wanted to address one of these questions, and then also just say that, and just to add one other detail about that case, is that, of course, our client and her children were separated for years. And while this went on, after she had been, really their sole and primary caregiver for their entire lives, and they had different fathers, and so they were separated from each other. And she's never really been able to get back, even, after it was all dropped, to having primary custody. And, I think things are changing and improving, but, just the incredible trauma to these children's lives over what happened. And really the research is, even before that stage, even before separation, even just the investigation and regulation of the family has tremendous impact on the family that's negative. Because once the state starts coming in and second guessing all the parents' choices and, surveilling them and sending police to their home, that it really changes the family dynamic and has negative impacts on children as well. I see there's a question about, did you get that answered by writing? Just about, from Patricia, about adopted children. I think, the studies do show that children who are adopted versus being long-term foster care or in group care do have better outcomes, but they're still much worse than staying with their original families. That when we I think obviously none of us ever want a child to be adopted when they could have stayed safely with their family of origin, for the child's sake, and of course the parents as well. That if we really supported parents in being able to have the basic necessities to raise their children safely, there would be much fewer children being removed and much fewer older children needing adoption.
I just really want to give a shout out to my colleague Shannon Wilber's work. I mean, Shannon, you've been calling out the need for this kind of shifting of our vision and priorities for years now. And I just want to say, you spent decades working on trying to, and successfully, make the child welfare system more hospitable to LGBTQ young children, to pass laws and policies prohibiting discrimination against those kids, and really working especially to make the transgender kids in those systems, make sure they get appropriate medical care. And that's been really, really important. But really, just as important, perhaps more important, is keeping those kids out of these systems in the first place. Those kids, and all kids, no kids should be in these systems. Maybe, sure, some kids who are really being genuinely abused need to be protected and removed from their families. But as Shannon said, the vast majority are taken away because of negligence, which is just riven with all, determination of what constitutes negligence is just almost completely constituted by intersecting biases, and it's families that at most just need some support. But Shannon, maybe it would be great if you could say a little bit about some of the work you've been doing, that upstream work, as you call it, to keep those kids in their keep LGBTQ kids in particular in their families. I'm thinking about, the Santa Clara project, but many other things you're working on now.
Happy to do that. Yes, we've been working in, I'll talk about Santa Clara County just because I think it's a good example of the magnitude of change that needs to happen, and how these changes need to happen across systems, because there's so many of these public systems that sort of work hand in glove with one another, and primarily child welfare and juvenile justice, there's a very strong connection there. And so when you're working in jurisdictions to think about how to move resources from these, I'll call them substitute care systems, up front into communities and families, you can't just work with child welfare. You can't just work with public health or just work with juvenile justice. You really need those agencies, first of all, to embrace this idea that it is a better way to invest resources, and families actually do much better when you shift those resources from the back end to the front end. And so in Santa Clara County, we're working on an initiative called Support Out. The meaning of which is, the objective of the initiative in this particular case is to make the kinds of sweeping changes we're talking about in one jurisdiction to improve basically the health and welfare of LGBTQ youth of color in Santa Clara County. So what that means is getting all of those public agencies at the table, as well as the really significant community-based organizations that are in the same communities where the zip codes where the kids are coming from. And when you look at data, it is always fairly clear where the overrepresentation happens, and it's in the poorer communities of color, where the vast majority of children in the foster care system and their families live. So our collaboration in Santa Clara County is with the courts, the public agencies, the lawyers representing these children, the community-based organizations, and really critically, the children and families themselves. Because any attempt to dismantle current systems and replace them with any kind of structures and practices without centering the people who are most impacted is, number one, not going to work. And number two is just as disrespectful and discriminatory as the current system. So we are really, really trying. And it's so not the typical practice that it's the kind of thing you have to kind of repeat over and over and over again. And who's at the table, and who's making decisions, and how are we involving families in making the decisions that affect their own lives? How are they very, they should be at the center of those decisions. So it's really exciting. Shannon and Kathy can tell you, I've been sort of laboring away at this for about 5 years now, and we're finally getting to the point where we're doing an official launch. We're having the first summit next week, actually. And I'll say that the name of the initiative, Support Out, is both the meaning of supporting young people to stay out of public systems and in their own families and communities, and also to support them to be out, to be safely out in their families and communities. I think it's doable. I think it requires a sort of constant attention and focus on what we're trying to do and reminding people over and over again that this is not business as usual. And, getting the decision makers at the table to really embrace the idea that what we're doing has to be radically different from how we've done things in the past. I think one of the selling points of this work has been, I will say bipartisan selling points of this work, is that the systems that we currently have are enormously expensive and ineffective. So they don't work and they cost a lot of money. That sort of resonates with a lot of people, that message. And so if we can say, look, we take public resources and reinvest them in a way that is more economically feasible and also more effective, we're going to strengthen our communities, save public funds, which we certainly know needs to happen at this moment in history, and create a healthier community. So it's really exciting work. So that's an example of, really focused in one jurisdiction. The Upend movement is a national movement, and so NCLR is really trying to be at the table on both levels. So one of the things that I get to do in Santa Clara County is sort of bring to the table what are people thinking about in the country? What are the big thinkers, the creative people who are looking at transforming these systems? What's the conversation? What are examples of things that are happening in other jurisdictions? So connecting, the local to the national and the opposite. So I don't know if that is what you were thinking of, Shannon, but anyway, stay tuned for more of this work.
It was, and I know we're running short on time now, but I just want to say, Shannon Wilbur and I, you've been doing it even longer than I have, but I'm going on 30 years now. And the one thing that is so hard working on LGBT youth issues, the one thing that is so hard is that all the statistics that we hear about homelessness, substance abuse, suicidality, depression, they have not improved in that time. And that is a searing indictment of our movement, and it's got to do this differently, and this work differently. And I've learned so much from Shannon, also from Caitlin Ryan and the Family Acceptance Project, about the importance, the root cause, the foundation of those devastating problems that face so many LGBTQ youth are really rooted in family rejection. And if we can support families to support their own LGBTQ kids in the families and the communities they live in, that we can transform this whole country. We can transform the society. just imagine if we lived in a world where LGBTQ youth were not facing those existential issues. It would, that would be a big, big change. And it's one that really, 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 really needs to happen. We just cannot go on as a movement year after year with these same statistics, doing the same old things that are not working. And that is just not okay. So I'm so grateful to work with you, Shannon. Nancy, I know you're on here. I hope you still are. People like you in our community who are really calling this out and saying, no, we need to do different. We need to do differently here.
And I'll just briefly add that, I think I completely agree. And I think that's such an important point that, how we support families to at least accept and still continue to care for their LGBTQ children is so important to the movement and, helping young people in our communities. But also that the interesting aspect of what all of this shows about the child welfare system is that when you look at LGBTQ youth who are in the system, it's not just youth whose families have rejected them. It's also young people whose families are supporting them. and
Mhm.
affirming them. And then, the societal norms are against those families as well, leading to the removal of their children. And that really what this shows is just this incredible regulation of families in not meeting up to this heterosexual, cisgender, white middle-class family ideal. And, with married parents who are biological parents, I mean, there's a lot that goes into this bias that really regulates how especially low-income families are able to, live their lives and make choices about their children. And I will say that I got to hop off a couple minutes early, and I know we're about to wrap up. But thank you all so much.
Thanks, Kathy.
Thank you so much, everyone, for joining us. Kathy, thank you so much for those last words, and I do know you have to take off. Everyone, thank you so much for being here. For the amazing panelists, thank you so much for just your thoughtful and intersectional perspective in talking about this, and so quickly, and making sure that we're understanding. Everyone, you can find out more about us at nclrights.org. It's a pleasure having you. Have a great one.